This podcast is not intended as legal advice. If you're in need of legal services, please contact 602-375-6752 to set up a consultation. You're listening to the official podcast of the Law Office of Libby Banks, Estate Planning, Wills, and Trusts. Hosted by Libby Banks and Travis Meyers, your estate planning attorneys in the Phoenix Valley.
All right, you're here with us, the Law Office of Libby Banks. I'm Libby Banks.
And I'm Travis Meyers on the Law Office of Libby Banks official podcast.
Which is so awesome. Well, today we're starting our series about estate planning myths busted. So what we want to do is clear up a lot of those myths that keep people from doing their planning or doing planning that doesn't actually serve their families when they're gone. So first of all, Travis, true or false? If I have a will, that's all I need to avoid probate.
Yeah, that's false, Libby.
Really?
Yeah, there's a lot more that goes into avoiding probate that we'll talk about in a little bit. But now I'll ask you, if you type up a will and sign and notarize it, is that enough to avoid probate?
So it actually isn't, because that is not a valid will. As a matter of fact, you remember Aretha Franklin, when her estate was being probated, they found a handwritten notebook in her couch. That is more valid than your notarized, signed document that you put together.
More on that later.
Yes. Some other myths that we'll dispense with, maybe a little today and more in our future podcasts. One is, if I have a simple estate, and by that I mean I've got a house, I have a stock account, I have a 401k, everything's going to transfer just fine to my wife or husband and then to my kids. I'm not going to have any legal problems. What say you, Travis?
No, and I do hear something very close to that from many of our clients, something to the effect of, everything in my life is simple. I don't need estate planning at all. My family will just figure it out. And in so many cases, that's just not what ends up happening.
Absolutely. And we help those people, but sometimes it's a really difficult situation and very sad along the way. The other one I hear is, well, I have a simple estate, so a trust is just way too much for me. What do you think?
Hard disagree. There is, I tell many clients, and we'll talk about revocable living trusts and different kinds of trusts in future episodes, but there is such thing as having a simple trust, and that can be a really effective tool to make things a lot smoother for your family down the road. Yes,
perfect. Yeah. And then we were talking earlier about some things that we're seeing pop up on Facebook, and that is the inexpensive bargain discount trust plans and will plans. Have you seen some of that as well?
Yes, I've seen a lot of online advertising for those services, and a lot of people come to us asking about those, or, they may have done one with a company that does a discounted services, but they're a little nervous about it, and they come to ask us if it's okay. And Libby, what do they tell you most of the time?
Well, often what we see are trusts that are just not well done. So, story time, I did have a client who came in and she just never really felt comfortable with that plan she got from a company who she was working with to get an annuity in place and offered this very discounted trust plan. So she brought it in for me to look at. There were no beneficiaries listed.
Yeah.
So that's, you really want someone who is doing your estate planning, not selling you a product or doing your financial planning. They really are all about how are we going to make things work for you with that estate plan. And estate planning lawyers are kind of the place to go for that.
Yeah, it really is an interesting concept. You know, a lot of people wouldn't try to sell their own house or wouldn't try to fix their own plumbing if they don't know how to do it. But a lot of people try their own hand trying to figure out a very complicated legal process. And, there is that old adage that you get what you pay for.
Exactly.
And I just think it's so important to talk with a professional that knows this area of the law and can also learn from you of what's important to you and what's important to your family. Because, 4 or 5 years ago, before I got into this area of the law, if I tried to do this on my own, there'd be so much that I missed because there's so much I didn't know back then that I know now that's important to make sure that your family is set up for success.
Exactly. And I know you've done some of this too, Travis, when we do the planning. Sometimes they've got a unique situation or a problematic situation, and we have the time and the desire to walk through that with them and come up with creative solutions. And we have the experience to have different thoughts about what we've seen work. So, and I know you've done that for a lot of our clients as well. So,
absolutely.
All right. So let's move on to our first myth. And so talk to us about why doesn't a will avoid probate, Travis?
Yeah, so let's take a little bit further of a deep dive into what a will actually is. If without any estate planning at all, the state makes assumptions as to what you want, right? They make assumptions as to who you want to be in charge of handling all of your assets and who you want to be getting all of your assets. So a will is something that gives you power to actually have a say in some of those matters. But there are some catches to that. It is only effective upon your death. A lot of people think it's this all-encompassing document that covers many different situations. It is just instructions of what happens with your assets after you pass away. And really, in order to actually be carried out and see those instructions go through, you have to go through that dreaded court process called probate. And last episode, we did talk about why people like to avoid probate quite a bit. We'll touch on that a little bit more later. But a will, in and of itself, is instructions to the probate court.
That's a great way to put it. Absolutely. Yes.
And it's important that in order for the will to be effective, that there are certain things that you have to formally do. So not only having everything spelled out in a way that makes sense to the probate court and can be actually carried out, but also some of the formalities that come with it, like needing to be notarized and witnessed and things along those lines as well.
Right. Yeah. And so talk a little bit about the probate process, because you're kind of our probate attorney. We've got other people in the office who can do it, but we've charged you with being part of the probate department and head of it. So talk to me about the timeline and what all is involved when somebody realizes, I've tried this will at the bank. I tried to get the realtor to list the house. Nobody will do anything. I have the will. Travis, what do I do? Why aren't they working with me?
Yeah, so there is a lot to this process. So I'm going to try and keep it as condensed as I possibly can. So really what the process of probate is trying to answer is a question of authority. Right. I may have mentioned this in the last episode, but nobody, if after you passed away, can just march into your bank and demand the money in the bank. That's stealing, and we're trying to avoid that as much as possible. So the authority in probate comes from the court. And in order to get that authority from the court, there have to be some things that happen. So if we have a will, you have to gather the original will and make certain filings with the court. And then the court turns around and issues you this, it's called a certified letter of personal representative.
Yeah.
And that is what gives the person named in the will, you might hear them called an executor or a personal representative, the authority to go to places like a bank, to work on selling a house if that needs to happen, to work with financial companies, to gather everything, put it in one place, an estate bank account, and pay off creditors, settle some last debts and obligations of the estate before finally making distributions according to what the will says at the end of the process to all of those beneficiaries. Now, that process takes a long time.
I was just going to say, so tell us more in case somebody says, oh, that doesn't sound quite so bad. I think my family can handle that. Talk about some of the trip-ups along the way. Like even before they can get started, they've got our fees to pay. They have court fees to pay. And what if they can't get access to any of the bank accounts?
There are some options out there, but they may be on the hook, at least initially, for paying some of those fees. And the court fees are at least a couple $100, and then you have attorney's fees to worry about as well. And those can oftentimes come out of your own pocket up front. And then those can be reimbursed to the personal representative, but they are reimbursed from the assets in the estate. And what your estate is, just as a baseline, is everything that you own after you pass away. And sometimes there are assets that are what we might call liquid, which cash is readily available. You can use some of that once it's in the estate bank account to pay yourself back for some of those administrative expenses. Sometimes it's tied up, and you can't access that for a long time. It might be tied up in a house that needs to be sold, which takes a certain amount of time. It might be tied up in stocks, which the personal representative has a duty to get as much as they can for the beneficiaries. So selling off some of that stock may have to be thought through and might not be as liquid to help pay off some of those administrative expenses. And that's just some of the things that happen right up front, right? You also have to contend with the creditors, right? So if there are things like medical bills or debts that somebody had when they passed away, those don't just go away.
And what about the mortgage? So the other issue that we see often is they can't get control of the bank account. So not only are they coming out of pocket to pay us and to pay the court fees, but until they get appointed, they've got to make sure that is the mortgage being paid? Is the electric bill paid? And sometimes if a client or the deceased person was starting to deteriorate, sometimes they discover it hasn't been paid for a couple months because the deceased person was starting to lose it, and they didn't realize it until they passed away. So just think about, coming out of pocket for those additional expenses while you're waiting for the court to get around to getting you approved as the personal representative. And I'll just say for anybody who's not in Arizona, Arizona's process is fairly easy, comparatively speaking. We have clients who've had to deal with California probates. We charge fees, and yes, they're expensive. They can be 2 to 3 times as expensive as the plan that we put in place for you. But California, they get a percentage of the estate that attorneys do, and it can take 3 months before somebody's appointed and able to access accounts. So for other states in particular, just know that we would be really much stronger about how awful probate is. Arizona's not terrible, but it's still expensive, time-consuming, and can cause lots of problems along the way, for sure.
Now, one more thing on the timing. By state law, the minimum amount of time that you have for what's called a creditor period, which is the amount of time that you have to give notice to those people that the deceased person had debts to when that time runs out, is 4 months. So that 4-month time is a long time in and of itself. You add the complications of trying to get things from the court at the beginning, along with doing an accounting and inventory of the assets and things at the end before distributions can be made. We're probably looking at least 6 months, more likely 8 months to a year for your average smooth probate.
And that's the smooth. That's no bumps.
Yeah.
I knew what mom and dad had. I know what the creditors are, et cetera. And then the other thing is we may have to keep the probate open just to file that last tax return, because when they close the estate, the personal representative has to certify that they've paid the taxes. So even if everything is smooth and we're ready to go, if we still have to file a tax return, we have to wait. We have to keep that probate open. So often we're have a probate open for 2 years. That's not uncommon, even with something that's fairly straightforward. So, yeah.
And the straightforward part is key, because this is directly going at the myth that I have a simple estate and my family will figure it out. It'll take at least 8 months to a year minimum to figure it out.
Yeah, absolutely. Absolutely. So let's talk about information about why it's important, even with a simple estate, to have some kind of an estate plan. And we're talking an estate plan, not just a will. So first, looking at what would your family do if you were incapacitated. So you're in that car accident, you're in a coma in the hospital, you're going to come out of it, but it may be a couple months before you're actually able to think about financial things again. It could be longer. Maybe it's dementia towards the end of life. How is your family going to be able to step in to pay the bills? How are they going to be able to get the house sold if you're not ever going back there, so that they can use those funds for your benefit, for assisted living care or whatever is needed? If you just have a will, or if you have nothing, you're in trouble, because they are going to have to go to court once again for what we call conservatorship. Mm-hmm. And so that is complicated, yearly reports, ongoing supervision by the court. So it's not just about what happens when I pass away. It's also what happens if I can't handle my own finances, and my spouse isn't here to help me, or I'm not married. And then if I don't have kids, who is stepping in? You know, my friends aren't going to automatically know that I would want them to help me. Or my sister may be in Minnesota and she doesn't realize how bad things are. So having that estate plan in place that really allows somebody to very quickly be able to handle things if you're incapacitated is an important piece as well. So
absolutely. And there's just so many little things about assets that people don't necessarily realize are important to handle for incapacity. Retirement accounts are one of them.
Yeah.
Right. When it finally comes time to reap what you've sown over the many years that you've been saving for retirement, a lot of IRAs, 401ks carry a penalty if you don't take a required minimum distribution. Now, what happens if you can't take that required minimum distribution? You're going to have to pay that penalty?
Yes. Everybody does. So that's not just some IRAs and 401ks. That's the government saying, you didn't pay your taxes on this money. You didn't take it out. So we're going to penalize you. It's tax penalties. So
what kinds of tools do people need in the estate planning sphere that will help them solve those issues?
Right. So, of course, in our office, we really love the revocable living trust because for things like who's in charge of selling your house, who can handle that stock brokerage account, who can access your bank accounts, having all of those in the trust with who is your successor trustee after you're not able to handle things, and how do they show that they're the ones now to step in is key. And it's the easiest way for them to step in. What we found with the financial institutions is they also love the trust. We love the trust. They love the trust. They are very amenable to, oh, you're the successor trustee. You've got the letter from the doctor saying, mom can't handle finances anymore because she has dementia or she's in the hospital and with a brain injury, whatever it is. And here's the pages from my mom's trust showing you that I'm the one who is to be in charge. Then they become a signer on the account at that point. And they have the duty to use those funds for the incapacitated person and not just for themselves, as opposed to adding them on the bank account, which we talked about last time is a very bad idea. Mm-hmm. So that's an easy way. And then what we need is that durable power of attorney for the financial matters. So the other place that we appoint that person to say, I want this person to handle any other legal or financial matter that I have. So the IRAs and 401ks that have to stay in the person's name, they can't go in the trust, sue the driver who ran over mom, and make sure that we get that lawsuit in place, deal with insurance companies, deal with Social Security or Medicare, all of those kinds of things. That durable power of attorney is necessary. If you don't have a trust, you still need that durable power of attorney, or even more, you need the durable power of attorney because that's where they're appointed for everything to handle things. So even if you have a will, you've got to have that durable power of attorney to make sure if you're incapacitated, your finances are taken care of for your benefit along the way.
Mm-hmm. Now, I've got a thought on that, Libby, that I think ties into a couple of concepts. So one thing you mentioned earlier was that the probate process in Arizona is a bit easier than other states. I've heard a lot of clients say that managing assets in general with beneficiaries or otherwise is also a pretty easy process to do as well. I also see clients coming in who think that they have these easy solutions for these complicated issues, like putting another family member on the deed to their house or putting another family member on the bank account with them. And I mean, it is fair to say that those are things that can make certain things smoother, but there are a lot of really negative implications that come to that. And I was wondering if you could speak on that a little bit.
Absolutely. So let's talk about the house, in particular here in Phoenix, where housing prices are really rising. So mom bought her house for $200,000. It may be worth $600,000, even $1 million here in Phoenix now. She puts her son or daughter on the deed thinking, well, then it'll go to them. It'll be a smooth process. When they go to sell the house after mom passes, they are going to have a huge capital gains impact. Whereas if they inherit that house, they will not have the capital gains selling it shortly afterwards. So that's a big one. I'm not going to go into detail over exactly how that works, but that is a big issue with putting somebody on the house. So that's one. Putting somebody on the bank account has also some implications. One is they are now owners of that account. So you may trust them. They may be honest. They may not rob you of that money. or they might. But if they don't, the other issue is, what if they are in a car accident and they get sued and there's a judgment against them, and they're starting to have collection proceedings? That bank account is theirs also. Now, they may be able to show that they were put on it to help mom out, but they're going to have to do that when the creditor goes to try to garnish that account. And they may not think of that. So all of a sudden, your account is potentially in that situation. Or in your child's divorce. Oh, he's hiding money. I know he's hiding money in that account. You know how nasty divorces can get. And so having your child on the account rather than having them as the successor trustee or accessing it through the durable power of attorney is just not a great idea. And then I'll speak to beneficiaries as well. So Arizona really does make it easy to use beneficiaries on everything, including homes. But some examples of why that is just a totally bad idea. Mom has 3 kids. She put all 3 kids on the house. When she passes, the 3 kids own the house together. That means they have to agree on who's selling it, how much they're selling it for. They all have to be able to sign. The problems with that can be all the way from son Frank moved in and he's not moving out and he's not signing anything to sell it. So now we're in court. 2, Frank is incapacitated and he didn't do a durable power of attorney or any planning, and there's nobody to sign for him until we go to court and get somebody appointed. So, again, that trust makes a much better situation. The house is in the trust. Here's the trustee. If it's Frank and he's incapacitated, we go down to the next person that you appointed as trustee. They're in charge of selling, and everybody gets their share. Just a much simpler, thinking about simple, that simple estate can also be simple on your passing if you do it right. And the trust is just a great way to do that.
Yeah, and people try to use payable on death or transfer on death beneficiaries as a way to avoid probate. And sometimes under the right circumstances, it might make sense to do that. But there are so many things that it just doesn't make sense to do that, and that people don't think about. One of them is much like we talked about at the beginning of the episode with the payment of expenses. See, if you have beneficiaries on all of your assets, the money just goes directly to those beneficiaries. So the person who's on the hook for paying for funeral expenses, for cremation, burial expenses, all of those types of things is on the hook themselves. There's no estate to reimburse themselves from in order to make sure that they're made whole for doing what you wanted them to do in the first place.
Right. Right. Yeah, your executor, if you put beneficiaries on your account, doesn't get money and then dole it out. It is automatically given to, not automatic, but given to the let's use 3 beneficiaries as an example again. So if Frank is your executor and he goes to the bank with the death certificate, they're going to say, thank you very much. Here's your 1/3, Frank. Can you give us the contact information for the other 2, or tell them to come in to get their 1/3 share? So if Frank's already paid for the funeral because, that was the first thing that needed to happen and he didn't have a death certificate yet, and if he's paid for some expenses and he's keeping the mortgage paid until the house gets sold with his siblings, he has to worry about when is he getting reimbursed. He might be able to get reimbursed from proceeds of the sale, or potentially go after his siblings if they won't contribute their fair share. And we have seen that in our office where somebody really just ended up eating all those expenses because the other siblings just wouldn't contribute.
Yeah. Which is another real benefit of a trust or a will. I mean, in order for the will to be carried out, we're going through probate, but at least in the will, it will say how your assets are being distributed. It will say who's in charge and who can be reimbursed for their time and expenses. The trust does the same thing, but by avoiding probate altogether.
Right. Yeah. Avoiding all the court expenses and all that time. So I think next time we're going to talk a little bit about the revocable trust and that myth that a trust is way too much for my little estate.
Sounds good to me.
All right. Thank you, Travis.
Thank you, Libby.
Thank you for listening to the official podcast of the Law Office of Libby Banks. If you're in need of an estate plan, please reach out to our team by either calling 602-375-6752 or emailing info@libbybanks.com. You can follow us on Instagram and Facebook. Just search the Law Office of Libby Banks. Free consultations apply to new and existing estate plans only. If an estate plan is not completed or was prepared by a third party, revisions will be given at an hourly rate. This has been a T-Door production. Music by Track Tribe.